All right, everyone, are you able to hear me? It's
Yes.
now 2 p.m.
Yes.
All right, this is the State Expedited Accusations calendar. I'm Judge Melanie Williams. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All participants, please be advised that this proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means that any member of the public can log on and watch this particular proceeding. All defendants, please pay attention. I'm going to explain some important constitutional rights. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding today. Has every member of the public defender's office had the opportunity to interview or speak with their clients?
Yes,
Good
Your Honor.
afternoon. Yes, Your Honor.
Okay, good to see you, Ms. Gant and Ms. Kim. I'm glad to hear that. Are there private, and Ms. McLeod, have you had the opportunity to speak with all of your clients? All right. Is the state requesting breakout for any cases? I'd like to take our breakout cases first.
No, Your Honor,
Your Honor.
but the state would like to make one request. We would like to address position 2, Mr. Bridges.
You would like to address that case first?
Yes, please.
All right, that makes sense. It's most practical, Ms. Falk. That was my inclination as well. Is the defense requesting any other breakouts that we could take after we do position 2?
Yes, Your Honor. I would like to request a breakout room for position number 6.
All right. So at the jail, if we could do position 6 after we complete 2, that would be ideal, all right?
What's the name for position 6? Because we did not.
David Gattas or Gattas, perhaps? All right. Good afternoon. Are you Aleem Bridges?
Yes, ma'am.
Mr. Bridges, your case number is 22 CR 005342H, in which you're charged with 8 counts of reckless conduct and I believe 4 counts of discharge of a firearm near a public highway or street, each with the offense date of August the 8th of 2022. Do you understand the constitutional rights I just explained to you?
Yes, ma'am.
All right, thank you. Mr. Howard, can I have his history, please?
The second adult arrest. Last was July 2019, Cosmetic Drug Act. It was a arrest out of Philadelphia, Pennsylvania. Do you want the juvie?
Yes, please.
All right. It was a criminal conspiracy, simple assault, ag assault, robbery, theft by unlawful taking, theft by receiving, and recklessly endangering. And it was adjudicated, I guess, in juvenile court in Philly. He's not recommended because I don't do firearm charges. So I
All
know
right.
what the assessment says, but no.
Thank you, Mr. Howard. Ms. Falk?
Your Honor, we do have Detective Garman with us here today, and I would ask that he be sworn in and that he give testimony on the facts of this matter.
All right.
Your Honor, if I may, I do object to Detective Garman providing testimony in this case. At this point, Your Honor, this is a bond hearing and the state is certainly able to establish the facts of this case without Detective Garman chiming in. This is neither a preliminary hearing nor a trial. And we believe that his testimony is not relevant to the hearing today.
Your Honor,
Duly noted, Ms. Gant. We're going to allow him to testify, all right?
Thank you, Your Honor.
Detective Garman, will you please identify yourself for the record? And then I'm going to swear you in. Please state your name.
Detective Demetrius Garman with the MARTA Police Department.
All right, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
I do.
All right, you can put your hand down, Detective Garman. Please very briefly give us the facts of the alleged facts in this case. I will give both Ms. Falk and Ms. Gant very brief opportunity to cross-examine at some point. Ms. Falk, are you about to request to lead this witness?
Yes, Your Honor.
All right, so I'll allow that. That might be more appropriate in this case. Go ahead, Ms. Falk.
Thank you, Your Honor. Detective Garman, I'm going to take you back to August 8th of 2022. Do you recall MARTA police receiving a 911 call in reference to a male with a firearm?
Yes, I do.
Okay, and can you tell me what the subject of that call was?
Oh, yes, on August 8th, I believe around 1940 hours, 911 dispatched several officers to the Emmett Park MARTA station in reference to an individual that was seen walking in the area with a large long gun, and it had came out that shots was fired at the Emmett Park MARTA station.
Okay. Were you able to locate shell casings as a result of this call when you canvassed the area?
Yes, when I was assigned the case on August 10th, I responded to the area where the incident occurred, and I was able to recover 4.223 rounds that came from a rifle.
Okay. Now, were you able to retrieve any video or any documentation that showed that a shooting had occurred in that area?
Oh, yeah. So earlier during the week when the incident happened on August 8th, I received numerous texts through social media saying that there was an individual shooting a rifle at the MARTA parking lot. That video was provided to me from the witness who actually seen the shooter, and it's his cameras, Mr. Pak Woo-hung. After reviewing the video, Mr. Woo-hung also stated he had other surveillance that showed the individual change clothes and enter the MARTA station. So with that information, I reviewed the MARTA cameras at the Emmett Park MARTA station, and I observed that subject entered the fare gates around 1940 hours after he fired the rifle outside the parking lot. So the individual came to the MARTA platform, the westbound platform, and boarded rail car 195 and traveled westbound towards H.E. Holmes MARTA station. With that information, I was able to attain his breeze card that he used to gain access to MARTA property. With that information, I was able to isolate it and track the individual towards Cobb County, Georgia. And I reviewed several footage, and I observed that subject wearing the same kind of clothing every time he appeared on MARTA property. And with that clothing was a black t-shirt that stated the word neighborhood raps. So with that, I searched information about neighborhood raps and noticed it was a restaurant that was near the location where the shots were fired. I'm sorry, go ahead.
Oh, no, I was going to say, when you went to neighborhood raps, did you make contact with anyone there who was able to assist you in identifying the defendant?
Yeah, so when I responded to neighborhood raps, they were closed due to a gas leak that they was having repaired. And there was another business next door, and I spoke with a worker at that business, and he provided me with the owner of neighborhood raps phone number, Miss Javon Nurse. So later on, I spoke with Ms. Javon Nurse and described the incident and the individual that I was questioning about. And she stated that her manager was familiar with the video and stated that he had seen the video himself on social media and identified the individual in the video as Aline Bridges.
Now, at that point, were you able to take Mr. Aline Bridges into custody?
Not on the day I received who he was. So that following day, myself, the Criminal Investigations Unit, MARTA SWAT team, and our tactical field officers set up an operation at Hamilton E. Holmes MARTA station. Mr. Bridges, based off his breeze car history, he frequents that station around the same time. And around the same time, around 9:20 a.m., our SWAT team, tactical field officers were able to take Mr. Bridges in custody as he entered the H.E. Holmes MARTA station.
Okay, and did you have an opportunity to Mirandize and question Mr. Bridges after taking him into custody?
Yes, once he was taken into custody, he was transported to our headquarters. And upon arrival, he was Mirandized and agreed to speak to me without his attorney. And during that interview, he admitted to firing several rounds in the park.
Judge, I object. This is why we objected initially. This is more for a preliminary hearing type of testimony to which our client is entitled to notice so that we could potentially produce witnesses or we could potentially participate in a meaningful way. But the state is basically attempting to accelerate the criminal process into first appearance. And the issue today is whether there's probable cause for him to be arrested. That's it. It's not an issue of guilt or innocence today. This is what separates our justice system from lesser governments, which is there's a presumption of innocence today. The issue is whether he's probable cause for him to be arrested, which the state makes out every day without live testimony. But this attempt to somehow establish guilt at first appearance is inappropriate. We don't have any discovery. We don't have a chance to challenge any evidence. That's why it's not appropriate for today. If the state wants a preliminary hearing, that should have been scheduled so that we could meaningfully participate, but Judge, we
Next
would.
thing, Mr. Howard, your objection is noted. Ms. Howard, Ms. Falk, very, very briefly, let's
I will
bring this
very
to a
quickly wrap this.
conclusion.
Yes,
And
you're-
then let's please get a recommendation as to just his bond from the state. I will allow a very limited amount of additional testimony. Mr. Howard and Ms. Gant, your objection is noted. Very briefly.
Yes, Your Honor, and I do have to establish the behavior for reckless conduct, so I am going to ask that question as Mr. Howard stated, is a probable cause hearing. Detective Garman, one of the things I want to ask you is, you stated that Mr. Bridges gave an admission. My follow-up question is, when in the area where this shooting happened, were there any residences in that area?
Yes, at 10, to the exact address, at 1083 Suite A and B, there were several people home during that time frame that observed him shooting and heard the shooting.
And did you speak to those witnesses, and did they give you statements regarding if they were in any fear of what was happening at the time?
Yes, I interviewed the pronunciation may be wrong, Miss Fatih Ahmed. That is spelled F as in Frank, A as in Adam, T as in Tom, I as in India. Last name is Ahmed, A as in Adam, H as in Henry, M as in Mary, E as in Edward, D as in David. I spoke with her residence, who is directly next to the parking lot where the shots was fired. And she said that she heard the first shot. She thought it was a train riding by, a train may hit something with the train system being as loud. But then when she heard several other loud noises, she looked outside and noticed the individual shooting an AR-15 and then walking toward the direction of her house. And she stated she was pretty much shaken up and scared for her life.
And these 223 bullets, are those consistent with those fired from an AR-15?
Yes.
Okay. And was there anyone else in that residence at the time the shooting happened?
Yes, her husband was in that residence, and his name is Mr. Again, the pronunciation is going to be wrong, so I'm going to spell it. It's going to be A as in Adam for his first name, R as in Robert, I as in India, S as in Sam, T as in Tom, O as in Ocean, N as in Nancy, last name of Bowers, B as in Baker, O as in Ocean, W as in William, E as in Edward, R as in Robert, S as in Sam. They both were present during the time that the shots was fired.
And
Right.
and
Ms. Falk,
Your Honor,
we're
just-
gonna need to wrap this up.
I
All right.
understand. Just one more question, Your Honor. And this type of weapon that was used, this AR-15, what kind of weapon is this? Is this a personal use weapon, a military grade weapon? What type?
I would say it's a military grade weapon.
Okay. That is all from the state, Your Honor.
And your bond recommendation, Ms. Falk?
Your Honor, if I may make my argument with my bond recommendation.
Yes, please.
Okay. So, Your Honor, the issue that we have here is, and the pretrial was not advised of kind of everything that was going on at this time. The defendant not only has a juvenile conviction for aggravated assault, robbery, a number of other charges, very serious violent offenses that the court heard from pretrial, but he also has an outstanding TPO, 12-month protective order in Cobb County, which is where he was headed back to and what Detective Garman observed. And that's against a victim, the victim, Sierra Brandon, in her request for a TPO, stated that the defendant had multiple rifles, was making verbal threats to her, and she was in fear for herself and the safety of her children. And as a result, a 12-month protective order was issued against this defendant, that he have no contact with her or her children, and most importantly, that he not possess any weapons whatsoever, and that he turn over any weapons in his possession to the Cobb County Sheriff's Office. I did have an opportunity to talk to the Cobb County Sheriff's Office. They said no weapons were turned over as a result of this. That order was June 9th of 2022. This incident happened August 8th of 2022. So less than 2 months after a protective order was issued for 12 months, telling this defendant to have no weapons, have no contact with weapons, and turn over any weapons, this defendant was observed walking down the street with an AR-15. We also had the chance to talk to Ms. Fatih Ahmad. When we did speak with her, and she apologizes for being unable to come to court, unfortunately, she had a work conflict and could not reschedule that conflict. She stated that she is in fear for her safety. She's in fear for the safety of her family. She stated that this was to her, a relatively safe neighborhood. She had always felt comfortable walking around her neighborhood. And she stated that this event has now caused her to feel unsafe in her own home. She went so far as to state that when the shooting happened, her husband was in a room of the home that faced a window that, according to Ms. Ahmed, had this defendant tilted his gun one way or the other, would have shot into the house. She stated that Ms. Ahmed has stated they no longer go into that room, Your Honor. They are no longer using a room of their home because they are so afraid of what happened on that date. She further stated that this defendant had been coming around the neighborhood. She does not know him to live there and does not know him to be a resident there, but he had been coming through that neighborhood on prior occasions with an AR-15. She stated they had seen him.
I object. I mean,
I understand,
where are
Ms.
we
Howard.
going with
I know your objection. Go ahead, Ms. Falk.
And this goes to the Ayala factors of risk of reoffense and danger to the community. And so what happened is Ms. Ahmed stated that she saw this defendant and other neighbors had seen this defendant walking through that neighborhood with that AR-15 prior to this incident. So what we have here, according to Ms. Ahmed, her own words, is a pattern of escalation. You are seeing a TPO where this defendant is openly carrying rifles and having rifles and talking and making threats. You have him walking through their neighborhood with an AR-15, and now he is shooting the gun. And we all have seen this, Your Honor. We have all seen Uvalde. We have all seen these kind of things happen. And when they happen, we all ask ourselves, how did we get here? And I am telling you right now, this is how we get here.
Objection.
And so our request is for, quite frankly, but for this being a misdemeanor, the state's request would be no bond, because there is no way in good conscience I would recommend a bond on this defendant. But I do have to, because these are misdemeanors. So the state's recommendation is a $25,000 bond on each count for a total of $300,000 surety bond. We are asking that he have absolutely no weapons. I feel like the TPO already said that and he has disregarded that. So we are asking again, no weapons. We are requesting that the court order a seizure of the AR-15 used in this offense. We are asking for a mental health evaluation and treatment, and we are asking for no alcohol or drugs at all. We do have some concerns based on talking to the family of the defendant, and that is why we're requesting the MHET as a part of this order.
Thank you, Ms. Falk. Is Detective Garman still with us from the
He is,
MARTA
Your Honor.
Police? Mr. Garman, I did not allow Ms. Gant to engage in any cross-examination. Ms. Gant, did you want to ask any follow-up questions of Detective Garman at this time before the court excuses him?
Not at this time, Your Honor. Thank you.
All right, Mr. Garman, you can be excused. Thank you so much for attending today.
Thank you,
All
Your
right.
Honor.
All right, Ms. Gant, if you will put on your case, please.
Yes, Your Honor. Good afternoon. I would just remind the court that at this point, these are allegations which my client denies. He enjoys the presumption of innocence under the Constitution of the United States. I would ask that Your Honor not consider any of my client's juvenile history. Regarding the TPO, we are unable to verify if the information that is presented to Your Honor regarding any restrictions for firearms is valid. Furthermore,
Your Honor, I'm going to object to that. That is part of the defendant's GCIC, which the defendant has access to as well.
Notice, Ms. Falk.
Thank you.
Please continue, Ms. Gant.
Furthermore, the state has not put forth any sufficient basis for ordering an MHET evaluation. I had the luxury of interviewing my client. I do not have any concerns whatsoever about his competence. Now, regarding Mr. Bridges is 21 years old. He has been in the Atlanta, Georgia area here for 1 year. He does have community ties, including an aunt. He also has a 1-year-old son who lives in this area. We are unopposed to any stay away conditions. We are also unopposed to any no contact orders. My client does not know neither Mr. Ahmed nor Mr. Bridges. Mr. Bowers, that is Ariston Bowers, the complaining witness. My client, Mr. Bridges, completed high school. He graduated with a 4.0. He also went on to study in trade school where he studied wood shopping, HVAC, cosmetology, culinary arts, and musical arts. He is currently employed at Neighborhood Wraps as a manager. He has been in that position for the past 5 months. Again, I did not hear about any convictions as an adult. This is his second arrest as an adult, which the court should consider only today. I did not hear about any convictions for violence whatsoever. I am requesting a signature bond. If Your Honor determines that he is ineligible, then I would ask for a bond of no more than $6,000. That would be $5,000 for each count. The amounts that the state allege for these misdemeanor charges is tantamount to no bond. These are misdemeanors. He is entitled to a bond, Your Honor.
And Your Honor, I just want to briefly respond.
Very briefly, Ms.
We have spoken, I'm not sure if this is the same aunt, but we have spoken to Detective Garman, who did have an opportunity to speak with his aunt. She stated he does not live with her. He comes over occasionally to shower, but he is not living with her. So we do have some concerns about his ties to the community for those reasons.
And I would
Also, I want to add.
Please allow Ms. Falk to continue, Ms. Gann. I will allow you to redirect the end. Please, Ms. Falk, very briefly. Go ahead.
This is not his second adult arrest. This is not his second arrest. He also had an arrest for essentially what would be tantamount to violation of the Georgia Controlled Substances Act here in Georgia, out of Pennsylvania. So again, that gives us additional reasons for both risk of reoffense as well as his ties to the community.
All right, Ms. Gant, you were saying something.
Your Honor, the basis of my objection was regarding what the aunt told the officer. That is hearsay, Your Honor, and I object on that ground.
Which is admissible in first appeal.
Okay, it's completely all right. Having heard extensively from both the state and the defense, at this time, I am not going to order the mental health evaluation. I am going to order the seizure of the subject weapon and issue that the defendant is to have absolutely no other weapons, knives, guns, or otherwise. He's going to receive a $15,000 surety bond for each count. I will calculate those charges as follows: 15 times 12. So that'll be a bond of $180,000. And he is to stay away from the Inman Park train station at this time. Is there anything further from either the state or the defense?
And I'm sorry, Your Honor, I was remiss in mentioning this. We did speak to the MARTA Police Department. They are asking for a permanent ban for him. So they do not want him anywhere on MARTA property.
Yes, he must stay away from all MARTA for sure and comply with any active suspensions. He will be reset to the SAP calendar on August the 25th, whereby bond will be readdressed, as well as the subject conditions at this time.
And Your Honor, we're also asking that he have no further contact with
the victims, yes, and no contact with either victim. Please spell those last names again, Ms. Falk.
Yes,
for the record.
The last name on that is we have Mr. Bowers and Miss Ahmet. So we are going to ask, let me just pull up.
I know we've spelled those names several times on the record.
I
would prefer if we chatted them to Miss Grace if possible.
I absolutely can, Your Honor.
Thank you. Mr. Bridges, I understand that you have some questions. The best thing for you to do right now so that you don't incriminate yourself is to speak with your attorneys following this hearing, okay?
Yes, Mr. Bridges, please remain.
Please don't make any statements. The state is watching, and anything you say can and will be used against you. All right, does that conclude? Okay, unmute him at courtroom 2. Please do not say anything that can be used against you, Mr. Bridges.
Okay, that's fine.
Mr. Bridges, please do not speak. I will give you a call. The judge has ruled. We don't want you to say anything that you think is helpful that could potentially jeopardize your case.
Can you please just give me 10 seconds? I promise I won't say nothing that will jeopardize my case.
I do not want you to speak. I do not advise you to speak at all.
But I have the right to speak also, though, right? It's not.
I advise you not to speak. I will give you
very briefly, Mr. Bridges. If I feel that you're saying too much, I will cut you off. What would you like to tell the court at this time?
My arrest as an adult in 2019 was because of a juvenile case.
Okay, please stop, Mr. Bridges. That may end up being used against you. Okay, please call Ms. Gant shortly thereafter. Okay, she can answer any questions you have regarding my ruling. I believe this case is now concluded. Is there anything further from Ms. Falk, Ms. Gant, or either Mr. Howard at this time?
No, Your Honor. May I be excused?
Yes, you may, Ms. Falk. Have a great afternoon. Best of luck to you, Mr. Bridges. That concludes your case at this time.
Thank you, Your Honor.
All right. All right, we will now move to position 6, the case of David Gaddis. Can we please be placed in a breakout? Whose cases is this, Ms. Gant?
This is Jay Kim's case.
Oh, Ms. Kim, that's right, you
Yes.
requested the breakout. If I could be placed in a breakout, if Ms. Gant would like to attend. Mr. Dudley, is this your case?
Yes, Your Honor.
If I could go in the breakout, Ms. Falk is asked to be excused. Will there be anyone else that needs to join you in that breakout, Mr. Dudley?
I believe it would be ASG Duncan would join in,
All right. Ms.
And
Duncan
Your
is
Honor,
free to join.
Myself and Ms. Johnson.
and Ms. Johnson, the ASG.
All right.
and
Me
Your
as well.
Honor, if I may, I do not need to be included in the breakout.
Yeah, I
Okay.
can go in with Ms. Kim, Judge, if you put me in.
All right, that's fine. If we could all be placed in a breakout room, I'd appreciate it.
Oh no, did she just interrupt me while I was interrupting you? back up. It's a little.
All right, we're back on the record for the case of David Goddess, case number 22CR005349A, in which defendant is charged with 1 count of battery family violence first offense with the offense date of August the 11th. Mr. Howard, can I have his history, please?
13 total. Last was 2015, criminal damage to property, 2nd degree. Simple assault, I'm sorry. They were dismissed. He got 2013 DUI, suspended license. Another 2013 DUI. And another one. He got a lot of DUIs. 2012 battery dismissed. Got a suspended license from 2011. And 1 arrest out of the state of Illinois. That was from the 80s. That's it.
All right, at this time, the defendant's going to receive a $2,500 surety bond. He is to have no further contact with the alleged victim and stay away from that address so long as the victim is there. He can return one time with a member of law enforcement to ascertain whether or not the victim is at that location. If she resides there, he must stay away. If she's no longer there, he can return to that location. He is to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either the state or the defense as it pertains to this case?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Goddess. Who do we have next at the jail?
We have Ms. Richardson.
Okay, that is position 10. Good afternoon, Ms. Richardson. All right, your case number is 22CR005350Y, in which you're charged with 1 count of theft by shoplifting, 1 count of disorderly conduct, 1 count of willful obstruction, and 1 count of criminal trespass, each with the offense date of August the 11th. Do you understand your constitutional rights? Can she be unmuted?
That's not my case.
Oh, no, okay. Your name is?
Yes.
Oh, your name is D.S. Richardson. Your case number is 22CR005331J. I do apologize for that. In which you're charged with driving in emergency lane, driving while suspended or license suspended or revoked, and drugs not in original container. Is that the correct case, Ms. Richardson?
Yes.
All right. Do you understand your constitutional rights as it pertains to this case?
Yes.
All right. Mr. Howard?
I got first arrest.
All right, thank you. Whose case is this for the state, Ms. Reed?
Hi, Judge. Yes.
It's good to see you. The state's position, please.
Yes, on this case, the state's asking for a $2,000 surety bond. The breakdown of that is $500 for count 1, driving in the emergency lane, $1,000 for count 2, driving with suspended license, and $500 for count 3, drugs not in original container. Also, the state's also asking for no drugs, alcohol, or weapons while out on bond. Do you want to go over the facts briefly?
Yes, please.
Okay. The date of the offense was August the 11th, 2022, and this occurred on I-20 westbound and Boulevard. The officer pulled over the defendant after being notified of a hit and run involving the defendant, but there was no damage to the defendant's car or to the other driver's car. But the defendant was seen fleeing the scene, driving in the emergency lane. The officer ran the driver's license, and it was determined that she had a suspended license due to a failure to appear on November 19th, 2019. And during the search of the car after she was arrested, the officer found 8 red capsules of an unknown substance in a clear plastic bag located in the center cup holder of the car. And again, this is her first arrest, and the state's just asking for the $2,000 surety bond. Thank you.
All right, thank you. Ms. Kim?
Yes, Your Honor. Ms. Richardson is 22 years old, Your Honor, and she has been here in Georgia for all her life. She has a currently job as a teacher, lead teacher at daycare. She's a single, and her parents and her siblings are all here in Georgia. She has been gainfully employed for the last 1.5 years, and she has a high school degree. We would like to request for signature on bond, as pretrial services also recommended for unsecured judicial relief. And this is her ever first offense, Your Honor. Thank you.
All right. I apologize, Ms. Reed. Were there other conditions that what the state was requesting?
The only other conditions, because of the drug charge, is no drugs, alcohol, or weapons while out on
Okay.
bond.
I was making sure that there wasn't a driving request, which I wasn't inclined to do at this point. At this time, the defendant's going to receive a $2,000 signature bond through the jail, broken down 500 count 1, 1,000 count 2, 500 count 3. And she is to have no alcohol, drugs, or weapons.
Thank you, Your Honor.
All
Thank you.
right, best of luck to you, Ms. Richardson. Who do we have next?
Next, we have position 1, Mr. Atkins.
All right. Good afternoon, Ms. Atkins. Mr. Atkins, I apologize. Your case is 22 CR 0053444F, in which you're charged with simple battery family violence. Do you understand your constitutional rights? You said yes? I'm sorry, did you? I can't hear you.
Yes.
All right, thank you. Say it quickly so we can keep moving, all right? Mr. Howard, can I have the history, please?
Thank you, Elsie.
All right. Last arrest was 2020, driving without a valid license. He's on probation for simple battery DV, 20 CR 005-080D. September 2021, they gave him 12 months probation. He's going to felony court as well for some drug charges. All right, let me see if I see any other violence. Got a 2019 hindering person from making 911 call. It just says bind over the East Point. State might know the disposition on that one. 2018, possession of a knife or a firearm during a commission. Sale of marijuana. Possession of a firearm by a convicted felon or felony first offender. Theft by receiving felony. 2012, sale of marijuana. Misdemeanor possession of marijuana. And a 2012 simple battery trespass arrest.
All right, that's good. Thank you, Mr. Howard. All right, Ms. Duncan?
Yes, Your Honor. In this case, the events alleged occurred on February 10th, 2022 at 515 Fulton Street Southwest, number 2418. The victim in this case is, let me spell the name, my apologies. It's, the victim is, her name is Shantrice, SHANTRICE, last name Nufang, NOUEFANG. The state would also like to note that in that conviction in 2021, in case 20 CR 005-080D, for simple battery family violence that was against the same victim in this case. The defendant pled guilty in that case, and as a part of that plea negotiation, the defendant was to have no further contact with this victim and surrender all weapons. In this case, Your Honor, it is alleged that on the date mentioned, the defendant came to the victim, Ms. Nufang's home, and was banging on her door with a gun. Ms. Nufang notated to officers that the noise was so loud that she decided to let him in because she didn't want her neighbors to be disturbed. And once she let the defendant in the home of her apartment, they began arguing and yelling. He seemed aggravated. He wanted to see his child because they do share a child together. And once he became aggravated and started yelling, she asked him to return the child to her. And he got aggravated at that request. And while she was holding the child, he grabbed her by the back of her hood and drug her to the ground while she was holding the child, and continued to strike her several times, as noted by the warrant in this case. It is also indicated that the victim's 7-year-old daughter was home and heard the commotion between the defendant and the victim, and came into the room and was trying to get the defendant to stop hitting her mother. Their mother. We have a severe concern for risk of offense and intimidation of the witness in this case, Your Honor. We did get a chance to speak with this victim, and the state has extreme concerns given that this defendant does have a no further contact negotiated plea and a surrender of the weapons plea, and both of these things have been violated in this alleged offense. When we spoke to the victim, it was indicated that they actually currently live together and that the victim may be pregnant. However, Your Honor, we have a severe concern for all parties involved in this case, given that this victim was attacked while she was holding their child and actually struck. It's obvious that this defendant is not going to respond to legal processes, as this defendant has continued to ignore the negotiated terms of the plea made in his prior case. We have concern for the safety of this victim given the cycles of domestic violence. So the state is going to be requesting a $5,000 surety bond, no further contact with the victim in this case or her 7-year-old child. As far as the set of 3-year-old twins that they share, we'd ask for third-party contact, stay away from the incident location. At the time of incident, the victim did state that the defendant did not live with her. However, today it is indicated that she does in fact live with the defendant. So we're going to ask for that stay away. We're going to ask for a 4-week anger management program, no alcohol, drugs, and weapons, and no further violations of Georgia law. It is my understanding that the victim may be on the line, and if Your Honor wishes a sound for her.
All right, and I'm sorry, Ms. Duncan, the amount that the state was requesting, I did get the conditions. I did not catch the amount.
$5,000 surety.
All right, thank you. At this time, I am going to sound for Ms. Newsong, I believe is the last name. Ms. Newsong, if you would like to be heard, this is your opportunity to do so. All right, hearing none, we'll proceed. Who represents this defendant? Is it Ms. Gant? Yes, I see Ms. Gant is unmuted. Ms. Gant, please proceed.
Thank you, Your Honor. Mr. Howard Atkins is 29 years old. He has been in the Atlanta, Georgia area since 2008. He has family here, including his mother, a sister, and a set of twins. The twins are 4 years old, and he informs me that he has physical custody of the children. The children live with him and not the complaining witness that he shares them with Ms. Chantrice Newfong. Your Honor, my client also is adamant that he does not live with Ms. Atkins. He has not seen her. He denies these allegations strongly. He completed the 12th grade. At this time, he is unemployed. There is an opportunity for him to obtain a job doing some landscaping. He does not have the money to pay anything toward bond. He does not have any family to help him with bond. And again, my client strongly denies these allegations. He states that Ms. Atkins has a history of making false allegations against him. We are unopposed to the stay away. He does not want any contact with her. Your Honor, we are also opposed to the 4-week anger management class. My client does not have the means to pay for that. And it also imposing 4-week anger management at this time just basically implies that he is in fact guilty when we know that he is presumed innocent. I am requesting a signature bond on Mr. Atkins' behalf, and with regard to witness intimidation and reoffending, this incident again is alleged to have occurred in February. My client maintains that he has not seen her nor intimidated her even on that date, Your Honor. So again, I'm requesting a signature bond. If Your Honor determines that he's ineligible, then I would ask for a bond of no more than $1,000. Thank you.
Your Honor, if I may clarify my recitation of the facts, my apologies. I have several pieces.
Very quickly, Ms. Duncan. Go ahead.
Okay. He did not pull, in this case, she was not pulled by the hoodie. She was she was dragged off of her bed and punched in the face, and the child came in and attempted to stop him. As stated previously, the state would like to note to the court that the victim stated to our victim advocate this morning that she is currently pregnant by the defendant, and she also told our victim advocate, I was just notified that before she talked to the advocate, she had just gotten off of the phone with the defendant at the jail. So our concerns for this victim remain, and we would ask for the bond as stated.
Mr. Atkins, please do not speak. Please do not speak. The judge is about to rule.
Yeah, please, Mr. Atkins, please don't interfere with Ms. Gant's ability to do her job. Anything you say can be used against you, and the state is listening. All right, at this time, Mr. Atkins is going to receive a $3,000 surety bond. He is to have no further contact with the alleged victim, in this case, last name Newfong. He must stay away from the incident location. He can return one time with a member of law enforcement to get any items that may still be at that location. He is to have no weapons, drugs, or alcohol, and he can arrange transport of the children through a third party.
And Your
All
Honor,
right.
we do not need the law enforcement escort. We do not need
Okay.
law enforcement escort.
I'll still leave it on the order just in the event that it is necessary at some point. Mr. Atkins, again, the best thing for you to do is to speak to your attorney. What questions do you have, Mr. Atkins? Please unmute him at courtroom 2.
First of all, I don't have 3 twins by her. We have 2 twins.
Mr.
Okay, whatever children you have, all right?
She said it was three identical.
Okay, no,
No,
don't
Your Honor.
argue. Please don't argue the facts. I don't want you to clarify anything for the state. This is not the time. We're not trying your case today. We're just setting you a bond, okay?
All right.
All right. I will please call Ms. Gant, all right? Best of luck to you, Ms. Atkins. Who do we have next?
Position number 3, Mr. Carr.
Okay, good afternoon, Mr. Carr. I'm going to start reading your case. It's 22 CR 005343G, in which you're charged with simple battery family violence with the offense date of October the 16th of 2021. Do you understand your constitutional rights?
Yeah.
All right, thank you, Mr. Howard.
Second arrest. Last was 2017, ag assault, dismissed. Battery DV, criminal damage to property, 2nd degree. The battery DV was amended to just battery, and the criminal damage was amended to disorderly conduct. Those were convictions out of the cab. And I'll defer to you
Okay.
for the email.
All right, thank you. Ms. Duncan?
Yes, Your Honor. The incidents alleged in this case happened on October 16, 2021 at 2023 Campbellton Road, Southwest, Unit 4. The victim in this case is Tatiana Christian, Tatianya Christian, common spelling. In this case, the state is going to be requesting a $3,000 surety bond, no further contact with the victim in this case, third-party child contact, a stay away from the incident location, 2 weeks anger management, no alcohol, drugs, weapons, and no further violations of Georgia law. The facts as it relates to this case are the ones that were said previously. However, Miss Christian called 911 and she stated that her child's father had came over and attacked her. He came over to bring milk and water for the child. However, he had been aggravated the entire time that he was there, and he began to yell at her. While he was yelling at her, the victim in this case decided that she wanted to take her child back, and that once she asked him to give the child back to her, he became irate, and then he dragged her by her hood down to the ground and began striking her with a closed fist while she was holding the child. There was a third-party independent witness to this case, a Miss Charmaine Wright, who was there, and her account of the events were corroborated as the same as those of the victim in this case, Miss Christian. In this case, we have a concern about the risk of reoffense and intimidation of the witness. She did state at the time of the incident they do not live together. That battery conviction was not the same victims. However, it does show the state that this defendant does have some violent tendencies. So we have a concern for the safety of this particular victim, given the nature of the offenses alleged, and there was a child involved while the striking was occurring, according to the victim. So we're going to ask for that bond of $3,000 surety, no further contact, third-party child contact, the stay away, 2-week anger management, no alcohol, drugs, and weapons, and no further violations. The state was not able to make successful contact with this victim. So out of an abundance of caution for her safety, we'll request a bond. We'll ask for the bond as requested.
All right, before I go to Ms. Gant, I apologize. I'm going to sound for Ms. Christian. Ms. Christian, if you're on the Zoom and wish to be heard, this is your opportunity to speak. Ms. Christian, all right. Ms. Gant, please proceed.
Thank you, Your Honor. Mr.
Are you here, Ms. Christian?
Hello?
You have to, we can't see you. You have to be visible on the screen, Ms. Christian, if you wish to speak.
And Your Honor, if I may, I would ask that Ms. Christian limit her testimony to her desires for contact with my client.
And the state would object as any testimony is relevant to the IALA factors as your.
I think I understand both positions. We'll allow Ms. Christian to speak if she wishes with both objections duly noted. Ms. Christian, do you wish to make a statement?
Yes, like I want him to be around his child.
Stop. Before you start talking, we have to be able to see you. All we can see is the top of your head. And we need you to raise your right hand. I have to swear you in. Do you swear? I still can't really see you. Pull it down some more, okay? We have to know that this is actually you. Okay, do you swear and affirm that the testimony, hello, baby. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, I understand that the baby is there with you, but I'm gonna need you to move him to the side so that we can hear you. This is court, all right?
Okay.
While the court sympathizes, we have to be able to see and hear you, all right? Ms. Christian, you are under oath. What we are most interested in is whether or not you wish to have contact. Very limited other testimony will be heard. That is what the court is most interested in, okay?
Yeah. So I do want contact with Deontay because I want him to be around his child and be in his child's life. So.
All right, I understand that you want him to be around the child. That will be possible even if he didn't have contact with you. The court's question is, does he wish to have contact with you? Do you wish to have contact with him? Ms. Christian? Okay, Ms. Christian? Is anyone else having problems hearing Ms. Christian, or is it just my Zoom conference?
I am as well, Your Honor.
Okay, Ms. Christian, the question that I have is, do you wish to, he will have contact with him?
Yes.
With you, all right? So you wish to have contact on your own with him, regardless of the child?
Yes.
Okay. Very briefly, if I let Ms. Duncan ask a question, Ms. Gant will be able to cross. Very quickly, Ms. Duncan.
On October 20.
Your Honor, I object.
I know objection is noted. Go ahead, Ms. Duncan.
On October 16, 2021, did you call the police to your home?
Yes.
And on October 16th, 2021, did you report to the police that the defendant in this case struck you with a closed fist?
I don't remember, but I know I called.
All right.
Thank you.
All right, Ms. Gant, any follow-up?
No, Your Honor. If I may just proceed with my bond argument.
Yes, please. Please go for it, Ms. Gant.
Thank you, Your Honor. Mr. Deontay Carr is 24 years old. He has been in the Atlanta, Georgia area his entire life. He has his mother here, and he also shares a 1-year-old child with the complaining witness, Ms. Tatiana Christian. He also has 2 additional children, ages 2 years old and 2 months. Mr. Carr informs me that he completed high school. He is currently employed at Mellow Mushroom on a part-time basis. He denies the allegations, Your Honor, and I would bring to the court's attention that this incident is alleged to have occurred back on October of 2021. I did speak with Ms. Christian. In fact, I invited her to this hearing to let the court know that she wants to continue having contact with Mr. Carr. They have been co-parenting since that time. I would ask that the court not impose a stay away at this time, and that Your Honor order no violent contact. Furthermore, I am requesting a signature bond. The report that I received states that he is recommended. If Your Honor determines that he is ineligible, then I would ask for a bond of no more than $1,000. Thank you, Your Honor. And also, we are opposed to the 2-week anger management class, again, that implies that he is in fact guilty and he is presumed innocent at this time, Your Honor.
Thank you, Ms. Gant. Ms. Duncan or Ms. Gant, anything further?
The state would just review its concerns about the IALA factors present in this case, nothing further.
All right. At this time, the defendant is going to receive a $3,000 surety bond. He's to have no further violent contact with the victim, last name Christian, and he is to have no weapons, drugs, or alcohol as a condition of that surety bond. He will be reset to the SAP calendar on August the 25th.
Thank you.
All right. All right, anything further?
Your Honor, if I may, before we move to the next case,
Yes.
there is another defendant who has been added for today. It's a Jason Raw. I don't know if that defendant is in the courtroom. It's 22 CR 00. My apologies.
Miss Grace, do you have that position? I didn't receive an add-on calendar, so if there is
No,
an
ma'am.
add-on,
No, Judge, they took that case back off the calendar for whatever reason.
I think I saw an email earlier that the accusation was not received in a
Yes.
timely manner.
Yes, they initially took it off, Your Honor, because there was some dispute with Superior Court. However, it was filed by Deputy Falk and has since received a CR number since we've been in court.
Yes, ma'am, Your Honor. Mr. Jordan just did an add-on calendar. He's about to send it out.
All right.
Your
All right.
Honor, we did not have any chance to interview our client yet because we thought he was removed.
Is that defendant in the courtroom? Can he give Ms. Kim a call now?
We don't have him because he went on the calendar of the pull sheet.
Is it possible for him to be pulled so we can see him today? Or no?
He'll be reset. He'll have to come tomorrow.
All right. Unfortunately, I'm hearing from the jail, we have to reset to SCA tomorrow.
If we could wait to the end and possibly see if he could be pulled, we don't want to run into a Riverside issue, Your Honor.
I've asked the jail if it's possible to bring him before the end of the calendar, would you do so at courtroom 2?
Your Honor, we have to locate him because we were not, we have to go get him for you.
I understand. Just please try. If you can't, we will reset, but if you give it your best effort, and I know Ms. Kim will need to speak to him as well, so that'll take additional time. So if it's possible, we'd appreciate it.
May I have the booking number?
The booking number is, 1 second.
But in the meantime, who do we have before us?
Position number 4, Mr. Davis, Jaquarius Davis.
Okay, I'm gonna go for it. Ms. Duncan, if you would put that in the chat so they can see about pulling that other defendant so we can keep going. Mr. Davis, your case number is 22 CR 005347F, and what you're charged with 1 count of battery family violence, which is your first offense, with the offense date of April the 26th. Do you understand your constitutional rights?
Yeah.
All right, Mr. Howard.
12 total. Last arrest was in March, failure to appear.
Oh, Lord, they put it on.
He's on probation for possession of marijuana with intent, felony obstruction. He should get off of probation for that on Monday, because the disposition date was August 15, 2018, 4 years, 18 SC 159231. As an open case, possession of a Schedule 2 controlled substance, improper backing, driving without a valid license. 21.
Anything violent, Mr. Howard?
Yeah, the 2015 armed robbery, ag assault, 2 counts. I don't know the disposition of that.
All right.
Mr. Davis, please remain silent, sir.
You got a dormant bench one I saw. Simple battery DV. I think it's Judge Richardson. One of those judges, I forgot who.
Okay.
And a
That's
2021 probation violation.
Okay, that's good. Thank you, Mr. Dudley.
Yes, Your Honor. This incident took place on April 26, 2022 at 1770 Camilton Road Southwest. The victim, Nadia Bussell, Naudia Bussle, had drove to pick up the defendant from work. The defendant and Ms. Bussell have a daughter together. While she was taking him from work back to his place of residence, the defendant began to argue with Ms. Bussell about trivial matters. The defendant then escalated the argument and slapped Ms. Bussell in the face several times. When she stopped the car at his home, he took the keys out of the ignition and ran from the car. Ms. Bussell attempted to get her keys back from him, and then he pushed her to the ground and started slapping her again. Ms. Basile was able to get her keys and was able to drive to a nearby gas station where she called the police. The defendant walked to that nearby gas station and continued his attack on her. He bit her on the back during that attack, during the second round of that attack. And Officer R. Smith who responded to that call, observed visible injuries to her wrist and her back. Your Honor, this defendant has an open case for battery family violence from 2021, and that case number is 21CR002853F, and he was out on a $1,000 cash bond, which was initially a $3,000 surety bond. And that case is the case that is in bench warrant status. And while out on this cash bond, he proceeded to commit this violent offense, Your Honor. It appears that the defendant does not know how to keep his hands to himself, and we would like to recommend a $2,500 cash bond. Stay away from the incident location. We are unclear if the victim resides with the defendant. We will defer to the state on that matter. A 8-week family violence course, no further contact with the victim, a third-party child contact, and no alcohol, drugs, or weapons.
All right, I'm going to sound for Ms. Bussell at this time. Ms. Bussell, if you're present on the Zoom conference and wish to be heard. All right, hearing none. Ms. Gant?
Thank you, Your Honor. Mr. Jaquarius Davis is 23 years old. He has been in the Atlanta, Georgia area his entire life. He shares a 2-year-old daughter with Ms. Nadia Bussey, the complaining witness. Your Honor, he completed high school. He went to the 10th grade, but he went on to obtain a GED. My client is unemployed at this time, Your Honor. He was most recently employed at PetSmart. He lost that job, Your Honor. He denies the allegations. He stated that this never happened. Furthermore, I am requesting a signature bond on Mr. Davis's behalf. He is presumed innocent in any open cases as well as this case. We heard from pretrial about an incident in 2015. Mr. Davis is 23 years old. Anything that happened in 2015 would make him a juvenile, age 16, Your Honor. So I would ask that you not consider that. According to my research in Odyssey, Mr. Davis received a $3,000 good bond for the 21CR002853F. I do not have any records regarding a cash bond. I am requesting again a signature bond on Mr. Davis's behalf. If Your Honor determines that he is ineligible, then I would ask for a bond of no more than $1,000, and that would be a surety bond. I did have the occasion to speak to Nadia Bussey. I did provide her information for the link, but she informs me that she is currently working at QT. She did not believe that she would have an opportunity to have a break. This incident is alleged to have occurred back in April. They have been co-parenting. Your Honor, I would ask that Your Honor issue a no violent contact order, that there not be any stayaways. We are certainly opposed to the 8-week FVIP as proposed by the state. My client is presumed innocent. And furthermore, he is unable to afford an 8-week FVIP, and we do not want to put him at risk of violating any bond conditions. Thank you, Your Honor.
Thank you, Ms. Gant.
Your Honor, the state would like to note that his juvie record is relevant for bond according to the law, and that he also has 2 FTAs in 2021 and 2022, which also provides the state concerns that he is a potential flight risk. And that while he was out on bond, we also reiterate that he was rearrested for another violent offense.
All right, thank you, Ms. Dudley. I think we've made those facts clear. At this time, the defendant is going to receive a $4,000 surety bond. He is to have no further contact with the alleged victim in this case, and he must stay away from the incident location, which we believe is on Campbellton Road. He is to have no weapons, drugs, or alcohol as a condition of those surety bonds, and he will be so reset to the August 25th SAP calendar. Is there-
Your Honor, if I may, I do apologize for interrupting. If the stay away is at 1770 Campbellton Road, that is my client's address. And he tells me that Ms. Bussey does not live there, nor does she have any belongings there.
All right, he can return with a member of law enforcement to ascertain whether or not the victim is there. And if she does not reside there, he can return to that location.
Thank
How much
you.
is that?
4,000. All right, best of luck to you, Mr. Davis. Who do we have next?
Petition number 5, Mr. Esinomo.
All right, good afternoon, Mr. Esinomo. Your case is 22 CR 005348E, in which you're charged for theft by shoplifting with the offense date of August the 2nd. Do you understand your constitutional rights?
That I do.
All right, Mr. Howard.
15 total. Last arrest was in May. Possession of drug-related objects, obstruction. He got an open shoplifting, giving false name, theft by taking, interference with government property. On probation for loitering problem. They gave him 9 months to serve, 9 months probation in February in Clayton County. Also has history in North Carolina. 2016 FTA. 2016 second degree trespass, injury to personal property, resisting an officer.
All right, thank you. That's good. Mr. Dudley, this is your case as well?
Yes, Your Honor.
All right, please proceed.
This incident occurred on August 2nd, 2022 at the Circle K located at 111 Boulevard Northeast. The defendant entered the Circle K and grabbed several food items and ran out of the store. The defendant returned to the store later again and attempted to shoplift, but was detained by the clerk. When Officer A.B. Miller arrived at the scene, the clerk had already let the defendant go. However, Officer A.B. Miller was able to view the security footage, and then Officer Sherman, who came later, also had a chance to review the security footage and recognize the defendant from a previous arrest. Your Honor, there is an open case here where the defendant is being charged with possession of drug-related objects and obstruction. That case number is 22CR 002925E. The defendant has been convicted for theft by shoplifting in 2020. He was arrested for theft by taking this year of 2022 and arrested for theft by shoplifting 2 times this year, once in March and again concerning this case, giving the state concerns for reoffense, along with the fact that in this case, he had stolen from the shop earlier and then came back again to shoplift again. As pretrial mentioned, he has 2 FTAs out of North Carolina in 2016, giving the state concerns he is a flight risk. The state is going to recommend a $2,500 surety bond, a stay away from the incident location, and a theft class, being that this is his 4th theft-related offense.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Richard Isenuma is 26 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here, Your Honor, but they are unable to assist him with bond. We are unopposed to the stay away at the incident location. My client completed high school and currently he is employed for a nonprofit where he collects donations. He denies the allegations, and Your Honor, he is presumed innocent in any open cases. I'm requesting a signature bond on Mr. Esanuma's behalf. If Your Honor determines that he's ineligible, a bond of no more than $1,000, and we are opposed to the theft class, Your Honor.
All right, at this time, the defendant will receive a $1,000 surety bond and he must stay away from the Circle K on Boulevard and have no alcohol, drugs, or weapons. Anything further?
Nothing from the defense, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Thank you, Mom.
Thank you.
Thank you all.
Next, we have Mr. Carl Hood Jr.
All right, Mr. Carl, they're okay. I thought that was the same person. It's not. Mr. Carl Hood Jr., your case is 22 CR 005346B, and what you're charged with simple battery, family violence, with the offense date of August the 11th. Do you understand your constitutional rights?
Yes, I do.
All right, I'm assuming
Honor.
that positions 7 and 8 are cross defendants.
Yes.
All right, and Ms. McLeod, which one do you represent? You're muted, Ms. McLeod.
Oh, I'm sorry, Your Honor. I represent senior.
You represent senior. Ms.
Yes,
Kim,
ma'am.
you represent junior.
Yes, Your Honor.
All right, we'll do these cases together. Ms. Johnson, you had an announcement?
That's what I was just gonna ask, if we can do one set of the facts.
That's my plan, so that we can, we're gonna move this all at once, hopefully. And I'm assuming that it'll be a similar recommendation for both from the state, but not always. Mr. Howard, can I have the history for the junior, please?
I got first arrest.
All right. Was he not recommended?
Yes, Your Honor.
He wasn't on the recommended sheet.
Yeah, Kim.
He was not recommended.
I'll take it.
You, okay, I was just curious as to why. All right. Ms. Johnson, is this your case?
Yes, Your Honor.
All right, please proceed on the case of Mr. Hood Jr.
Certainly. The date of offense is August 11, 2022. The location is 6015 Landmark Way. That's a Shell gas station in Fairburn. The officer was called to the incident location for a domestic dispute. Officer spoke with the defendant, Carl Hoods Sr., and he advised that he and his son, defendant Carl Hoods Jr., began arguing when he got into his son's face and pushed him. Defendant Carl Hoods Jr. then fell to the ground. Senior then advised they began punching each other on the ground. When the officer asked defendant Jr. what had taken place, he advised the two got into an argument that turned physical and they both pushed and shoved each other. Once they fell to the ground, the physical altercation continued and was broken up by off-duty police officers. The officers could not determine who was the primary aggressor. Both parties were then arrested. Your Honor, for this case, I would ask for a $2,000 surety bond, given the violence alleged and the risk of reoffense and possible influence of the witness. We ask for a stay away from the incident location, no further contact, no alcohol, drugs, or weapons, and 1 day of anger awareness. Your Honor, we do want the parties to have an opportunity to cool down. This incident did just happen as of yesterday. Also, given the age difference, it is a father and son case, Your Honor. We are asking that there be no further contact at this time, and we can reconsider at a later date.
Were you requesting to stay away from this case? It was a gas station.
Yes, Your
Okay.
Honor.
All right, understood. Mr. Howard, before we go back to Ms. Kim and Ms. McLeod, can I have the history for senior, please? Mr. Howard?
Oh, my bad. I'm here. What you had?
The history for senior, for position, the father, Carl Hood Sr.
This is fourth arrest. Last was 2010 simple battery. It was reduced to disorderly conduct, a city ordinance. That was a conviction. He has history out of Florida, but it's old, from the 90s.
Okay.
I'll take both of them. Yeah, I'll take both.
All right, thank you. That's not to say that that's what I'll do, but thank you for that recommendation. All right, Ms. Kim, please proceed for the defendant before you.
Yes, Your Honor. Mr. Junior is actually 27 years old, and he has been here in Georgia for about 18 years. He has a 3-year-old child, and of course, his father's here. His mother resides in Florida, but he has most of his relatives here in Georgia. And also, he starts his new employment this coming Monday, August 15, to deliver the beers. So we would like to make sure that he gets out of the jail today so that he can get ready for his new employment. He graduated from high school. He has 3 years of college experience for accounting and motorcycle mechanic, Your Honor. And I'm really glad to hear that pretrial service will take him. Thank you.
All right. At this time, Mr. Hoods Jr. will receive a $4,000 signature bond through pretrial services. He is to take a 1-day anger awareness course. He is to have no further contact with the victim at this time. It can be revisited at a later date. And he is to have no weapons, drugs, or alcohol as a condition of that signature bond through pretrial.
Thank you, Your Honor.
Anything further from either the state or the defense?
Nothing.
Not for this client.
All right, let's go to Mr. Carl Hoods, please, Senior.
I believe Junior wanted to say something to the court, Your Honor.
Okay, very briefly. Go ahead.
No,
We advise against it. You got a signature bond. Do you have a question regarding the bond?
Don't say anything.
Okay.
You can call me. I'll call you too.
And we have Mr. Jason Raw here also.
All right, we're gonna do the case of Mr. Hood Senior. Okay, Mr. Hood, your case is 22 CR 00435 435D, and what you're charged with simple battery family violence with the offense date of August the 11th. We've heard the alleged facts in this case, Ms. Johnson. We've also heard the history. What is your bond recommendation?
Given the previous charge of simple battery family violence, even though it was downgraded, Your Honor, I will be asking for a $2,500 surety bond. Given the violence alleged and the risk of reoffense, I also ask for a stay away from the incident location, no further contact, no alcohols, drugs, or weapons, and 1 day anger awareness. And again, we can't revisit the no further contact at a later date.
All right, we're gonna amend the last order to add no, stay away from the incident location as well. Ms. McLeod?
Yes, Your Honor. My client is 51 years old. He is married. He is the father of 4 adult children and 5 grandchildren. He and his son, they actually do need to have contact, Your Honor, because one or the other will be unemployed otherwise. They actually work together. My client manages a store and his son works there. He tells me that he and his son have already reconciled since they've been in the jail. It was a very unfortunate incident. And, you know, he really wants to put this behind him. He has high school education. He is a settled person. He lives here and works here in Atlanta. As I said, he has a wife, he has 4 children, he has grandchildren. Any history that he may have is extremely remote and insignificant to what happened, Your Honor. He's a family man. This is really unfortunate. And I think he qualifies for a signature bond, Your Honor. Pretrial said that it would take him. And I would ask the court to give him a signature bond so he can get out of jail, go back to home to his wife and his children, well, his adult children and certainly to his grandchildren. Thank you, Your Honor.
All right. At this time, he will receive a $6,000 signature bond through pretrial services. The no contact orders will remain at this time, as I do not believe there's been a sufficient cooling off period. He is to have no weapons, drugs, or alcohol and complete a 1 day anger awareness course. Is there anything further? And he is to stay away from that incident location as well. Anything further from either party?
I do have a question, and you don't have to answer, but is the incident location at the work location?
That was
that where the
understanding.
It's not the work location.
Okay, it's not?
No, because what they got on file is the gas station. It never happened at the gas station.
Okay.
It doesn't, Mr. Hood, it's okay. You can call me and we can talk about that.
Yes,
All right, so are we modifying the stay away location at this time, Ms. Johnson? That part is unclear to me where this actually takes
The gas
place.
station is fine, Your Honor.
That's what I have on the warrant, Your Honor.
Yes.
Okay, well, just don't go back to that gas station if that's the incident location, the 6015 Landmark
The
Way.
gas station, Your Honor.
All right. All right. Best of
Your
luck to you.
Honor.
Yes.
I do apologize for interrupting. Regarding position 4, Jaquarius Davis, I would like to clarify whether or not Your Honor ordered third-party transfer, and if so, if not, I would like to request that, please.
I have in my notes that I did, but perhaps I didn't say it out loud. I'm gonna amend position 4 to add third-party transfer if I didn't already indicate that. And I do apologize, Ms. Gann. I wrote it down. Whether or not I said it is not always, my thoughts don't always match my actions.
Right, and
All
I
right?
do apologize for interrupting. Thank you.
No, that's all right. That's more than fine. All right, we're gonna, the only position that remains, I know the add-on is there. Can we go to position 9 while I try to find the add-on? And Ms. McLeod, does that complete your business here today?
It does, Your Honor. It does.
All right. Yes, you can be excused. Begin enjoying your weekend, Ms. McLeod. Take care.
Thank you. Same
All
to
right.
you.
All right. I don't have the add-on yet. Can someone send it to me? And is this the case of Cornelius Reeves? Is Mr. Reeves before me? If we're not ready at Mr. Reeves, if the add-on is ready, I don't believe I have, let me see. Okay, I do have the add-on, so we could do that one. I'm open to either position at courtroom 2.
What you saying,
Were
you talking to us?
Y'all got Reeves?
Yeah, that's all fabricated.
Mr.
Do
Ross.
we have,
Go
ahead.
To Ms. Kim now.
Okay, is there another position we could go to? Can we do Reeves?
Reeves, his position was waived by, Attorney Kim.
Okay, Miss Grace, do you have that waiver of appearance from Mr. Reeves?
No, ma'am.
Okay, so we have to wait for Miss Kim.
Can we go over the camera?
We can, but it's so short today that there's not much to review.
Yeah, I know, but we may be another 30 minutes. So I was just trying to,
I understand.
use our time.
One question, if it does is Mr. Reeves being waived at courtroom 2 because of medical? Or is it, I'm trying to understand if he could be brought, he can't be brought today?
Is that him?
I believe he was medically reset because he, Mr. Reeves.
No, his appearance is waived.
Yes, you want to know what type of medical?
No,
She want to know why is it waived?
Why is his appearance waived?
he was sick.
Okay, so it is a medical waiver. Okay. Who do I have before me? Is this the add-on position, Jason Raw?
Yes, Your Honor.
Okay, Mr. Raw, your case number, let me make it 22 CR 005352J, in which you're charged with harassing communications with the offense date of August the 7th of 2022. You have the absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. This proceeding is being broadcast over the internet as a live stream. It is also being recorded. Do you understand your constitutional rights?
Yes, ma'am.
All right, Mr. Howard.
Oh, I don't have this issue. He wasn't on my pull sheet.
Okay, Ms. Duncan, we'll have to defer to the state for the history.
Okay, he has 4 cycles total. I have 2 DUI convictions, one from 2005, one from 2007. The defendant has an open Superior Court case 22 CP 211425, possession of methamphetamines. And there is an open TPO 2022 CV 368720, which was filed on August 12th of 2022.
All right, thank you. Your bond recommendation, Ms. Duncan?
The state in this case is going to be requesting a $3,000 surety bond. The incidents are alleged to have occurred. Well, the incident report for this is going to be 1105 Canton Street in Roswell. The victim's name in this case is Catherine Jacquith, Kathryn, Jacquith, Jaquith. In this case, Your Honor, the defendant is charged with harassing communications. So the state has extreme concern about the facts in this case. The defendant in this case kept sending text messages to Ms. Jacquith after she had told him on several occasions to stop. Initially, Your Honor, it's indicated that at one point, Ms. Jacquith had gone out to dinner at the North River Tavern, which is a place where the defendant in this case used to work. He somehow, even though he does not currently work there and wasn't working there at the time, gained access to their security and surveillance cameras and was able to watch Ms. Jacquith while she was out eating with her boss. He sent her photos of her being out with her boss and accused her of having an affair and called her several different derogatory names. Ms. Jacquith advised officers at that time that he has been using cameras and videos to watch her and take photos of her and sending her text messages of these things after she's told him on several occasions to stop. Screenshots of this evidence were provided to officers. On August the 4th, it's provided that she did in fact tell him to stop contacting her. Furthermore, she works at that 1105 Kenton Street, which is Uncle Jack's. And it's indicated that she sent the text messages to the officers confirming that he does not in fact work at that North River Tavern where he accessed their security cameras to take photos and videos of her. We were able to talk to the victim in this case, and for the record, there is an open TPO that was filed shortly after this warrant was taken out. That is the number that I provided to the court, and the basis for that TPO was the offenses alleged and additional offenses alleging and provided evidence that the defendant in this case has since continued to contact her and state things like, "I'm out to get you. I don't care if they told me to not contact you. I'm going to have a burner phone and a new email address. They won't know that it's me, but you will." And it's when we were able to contact the victim, Your Honor, she stated that the defendant is in fact her ex-boyfriend, but they broke up last summer. She stated in this past week, the defendant has since then continued to contact her after August by calling and sending emails to her job and trying to get her fired. She wants absolutely no contact with this defendant. And she wants him to stay away from her job. He works about a mile away from where she works. The victim has indicated to our victim advocate that she does not want to speak in relation to this incident, and we're not sure if she's on the line. However, she made her wish clear that she does not want to speak. Given the severe concern of the continued harassing communications and threats to get this victim, we're going to be requesting that $3,000 charity, no further contact with the victim in this case, stay away from her wherever she is, no alcohol, drugs, weapons, and no further violations of Georgia law. Nothing further from the state.
And her name is Duncan?
Her name is Catherine Jacquith, Kathryn, last name Jaquith.
Okay, I'm gonna sound for Ms. Jacquith, even though she's previously indicated to the state that she didn't want to make a statement. I'm still sounding to see if she would like to speak at this time and if she's present on this Zoom conference. All right, hearing none, Ms. Kim.
Yes, Your Honor. Mr. Ray Braw is actually 37 years old, and he does not work at 1105 Canton. However, he says that he's still employed at 1920 Tavern as a chef. So probably the